Hello again and welcome to our latest food law video. I'm joined today by Sian Edmonds and Tim Harris, and we are going to be talking a little bit about gene editing. And the reason we're talking about this is the UK government, has launched a consultation which will be running until the 17th of March on the question of whether gene editing should be treated differently to other forms of genetic modification. And effectively, what they're proposing to do is to take gene editing out of the definition of GMO, and so therefore it would fall out of the regulatory regime, which requires prior authorization before you put these products on the market. This means that those products which are developed just by amending the genes within a species could be much more easily placed on the market in the UK at least. Now, obviously, if one goes to the effort of developing these products, which will involve a huge amount of research and development and time, then you're going to want to make sure that you get the commercial benefits of those and they are protected by intellectual property. So that's why I'm here today with Sian and Tim to talk a little bit about what that means in practice. So first of all, Sian, perhaps you could tell us, what are the requirements in this area?
Absolutely. Thanks, Katrina. So, as you've mentioned, a patent works as essentially the reward for the investment put into an invention. So, in exchange for the disclosure that you provide to the world, you get a monopoly over that invention for a set period of time, which, provided that you maintain your patent, can be up to 20 years. In order to obtain a patent, there are some certain requirements that have to be met, primarily that the invention is novel. That means that it's new and it hasn't been disclosed anywhere in the world prior to filing your patent application, and also that the invention has an inventive step, and that is to say that it wouldn't be obvious to someone who is skilled in the art. By skilled in the art, what we mean is the person who the patent is addressed to, so the subject matter of that invention is very important in that respect. As well as those basic requirements, there are some exceptions to patentability. There is, and the reason why we're talking about this today is there is an exception for plant or animal varieties that result from essentially biological processes for the production of plants and animals, as long as they aren't microbiological processes. And there's been quite a bit of case law on that, on how that should be interpreted. And I think that Tim's going to talk about the main decision, which is pepper.
Mm. Yes, Tim, tell us about pepper.
Thank you, Katrina. Thank you, Sian. Absolutely, I'd love to. I think it'd be helpful just to quickly put pepper in context. So the UK is a signatory to the European Patents Convention, or EPC, as well as other international treaties that harmonise patent law. Now, the EPC is an international treaty, so it's not part of the European Union. It's got signatories which are both members of the EU and ones which aren't, like Iceland and Switzerland and of course now the UK. The EPC is governed by boards of appeal, and the ultimate tribunal is the enlarged board of appeal, and that's interpreted this provision, this exception to patentability, a few times, and as you said, the leading decision at the moment is called pepper, and that's provided some much needed and welcome clarity on this area of law. Now, the pepper essentially said that the patenting exception is limited, or at least it encompasses processes for the production of plants based on steps of sexually crossing the whole genome of plants and subsequently selecting them. So that's classical breeding. And so patents are now not available for plants obtained by those traditional techniques. And in contrast, in principle at least, processes involving other gene editing techniques like CRISPR and products obtained from those processes may be patentable if, of course, they meet the other tests which Sian explained.
Fantastic. So it means that it sounds like there is potential if the UK decides to deregulate gene editing for those inventions to be protected. Now, obviously, at the moment, this is a UK consultation, so we're talking about a change to the law in the UK only in terms of these products. We do understand the EU is also looking at this, but at least initially it's a UK position. And I just wondered, given that distinction and the importance of Brexit to this, whether Brexit makes any difference to what you've been talking about, Tim.
Well, that's an excellent question. I'm very happy to say that because the European Patent Office and the technical boards of appeal, they actually sit outside EU structures, as I mentioned, they won't be affected by Brexit. So patent law in this regard shouldn't be affected by Brexit.
Well, that's fantastic news. Well, thank you, Sian and Tim, and thank you for listening to our food law video. We'll be back with another update very soon.